All rise. Okay, you may be seated. Welcome to the afternoon session of the Kansas Court of Appeals. We're thrilled to be here in the beautiful Johnson County Courthouse and to be in person for one of the few times since we all rushed out of the building on March 20th, 2020 or thereabouts. I will call your cases in a minute. If you are and I'd like you to state your appearances when I do. And if you are the appellant, if you would let me know if you would like any time in rebuttal. You'll each have 15 minutes to argue, but the appellant can save some rebuttal time if they like. We are very familiar with the facts of your case. We've read your briefs, and in many cases, we've read the transcript and the court record as well. So you only have 15 minutes to present your case. We really don't need you to spend a lot of time on the facts unless you feel it's critical to the particular point you're making. We, of course, will unfortunately interrupt you, ask you questions, but we still hope you'll be able to get through what you want. I'll be timekeeper as the presiding judge. I'm Karen Arnoldberger, Chief Judge of the Court of Appeals. To my right is David Bruns, who joined the court about 1 or 2 months after I did. So we have about the same tenure on the court. Judge Bruns was a Shawnee County District Judge before he was appointed to the Court of Appeals. To my left is not our newest, but one of our newest judges, J.C. Hurst, who came to us within the last 18 months, about from private practice. So we are all very happy to be here today. We are looking forward to your argument. So we're going to start with case 124381, Daniel Ojeda versus State of Kansas. If the parties would step forward, state their appearances, please.
Please the court, Brett Loggeman for the appellant defendant. I would like to reserve 3 minutes of my time for rebuttal.
Okay, great.
May it please the court, Appellee State of Kansas appears by Assistant District Attorney Daniel Obermeyer, present and ready for argument.
Okay, great. So Ms. Loggeman, you may begin.
Please the court. We're here today on the appeal of a 60-1507 motion by Mr. Daniel Ojeda. For just a brief factual summary, this case came about on a pro se motion filed by the defendant following the affirmation of his convictions here in Johnson County. He was ultimately represented by an attorney. There was an evidentiary hearing in this matter, and then the motion was denied. He is since appealed. Some of the facts of the underlying case will become relevant as we go through the arguments, I believe, and so I'll skip those for now as part of the summary, and we'll get into them for the arguments. Judges, where I'd like to start today is the second point that was briefed, which is the decision to testify. The decision to testify was raised by Mr. Ojeda in his motion as his second point, and then it was argued as such, and that's why it was briefed as such. But today I'd like to talk about that first and foremost, because there's a lot to that decision to testify that I think should be reconsidered and is worth reconsidering. So as part of his motion, Mr. Ojeda had argued that he was essentially forced to testify, that he was not given a choice to testify or not provided with his options as to whether or not to testify. It was presented to him that this is what he had to do. And he has argued that forceful nature or that push to testify by his attorney was ineffective assistance of counsel, because ultimately there was testimony elicited from Mr. Ojeda at that time that was negative, that had a negative impact on his case. We know from the standard for the 60-1507 that Mr. Ojeda has to prove first and foremost that Mr. Smith was deficient in his performance, and then we have to overcome the hurdle that deficiency in his performance created a prejudice that harmed or created a harm for Mr. Ojeda.
Ms. Lagman, a question I have is, wasn't Mr. Ojeda's primary defense was that it was not a fully completed rape? And the only way to present that evidence would have been through Mr. Ojeda's testimony, because he was the only one that was the only person that could make that claim. So, although Mr. Smith, I think, denied that he told him he was forced to testify, I'm sure he probably told him, if you want that defense to be put forward, you're the only one that can do it.
I understand what you're saying, Judge. I believe, yes, to back up a little bit and take kind of each point here, first and foremost is that Mr. Ojeda's defense was that there was no penetration. And as
Right.
part of the crimes of rape and
Mhm.
aggravated sodomy, that would have to take place. I believe you're also correct that as far as direct evidence goes, the best way to be able to do that would be for him to testify. We have a situation where we only have two people involved in this particular situation. We have the victim who testified, so we have her direct evidence, her direct testimony, and then there could be direct testimony from Mr. Ojeda to contradict that. So that is an
Right.
option. What we get into in this particular situation is a couple of different things. So the first thing that I'd like to address is the fact that there was other evidence or other, the state had presented other parts of their case that could be and were actually used by Mr. Smith to try to contradict what the victim had said. So there was an expert that had testified for the state who had said that there was no DNA found in the places where the victim had stated she was penetrated. As Mr. Smith raised in his closing arguments and also I believe elicited through his cross-examination, wouldn't there be some form of physical evidence, say in the form of DNA, where one person has touched another person? And so his argument does not necessarily include direct evidence, but I think it does get to the level of raising a reasonable doubt as to the story. If we have,
But
excuse me.
as you know, Mr. Loggeman or Ms. Loggeman, Mr. Smith did raise that in the trial.
Yes,
So that evidence was also presented.
yes.
So then I guess this gets to the second point. How could this possibly be prejudicial then?
Right. You're exactly right that Mr. Smith did raise this. And so the effect that should have is the state's presented a victim who says this happened, and then they have an expert who says there's no physical evidence to it, and it possibly raises that reasonable doubt. I think it does. I would assert it does raise that reasonable doubt for a juror that maybe it didn't happen or it didn't happen the way she said it did. Something's kind of amiss. By going that extra step of trying to present direct evidence and putting Mr. Ojeda on the stand, it opened him up to questions that then would create a negative harm for him in the eyes of the jury.
And what was the negative harm? Was it the couple questions they got out before Mr. Smith objected about a prior or post?
Judge, I would assert that it was essentially there were a couple of statements that Mr. Ojeda made, I believe during cross-examination.
Right.
He essentially admits, yes, my intention here was to rape this woman, and I was so aroused by that
Right.
that I ejaculated prematurely.
Right.
Those are very repugnant statements. Those are the statements that I think when you hear those statements, you can see people's faces, it turns them off immediately. And so what happens here for the harm for Mr.
Well, how is that any more prejudicial? I'm trying to understand how that was any more prejudicial than his statement that rape was not complete, which was his defense.
His defense, right, was that
Uh-huh.
it was not complete. Having him get on the stand and admit, here's what I intended to do, and I was this excited.
Uh-huh.
I got to the point of essentially premature
Right,
ejaculation, right?
Right.
That having that admission to the jury
Uh-huh.
does for the jury, it turns them off of Mr. Ojeda, right? It now gives them reason to go back on their maybe initial questioning of what the expert said. So the expert said there's no physical evidence. There's a
Well,
possibility.
There was physical evidence. His DNA was present
Correct.
on her
Thought.
clothing and her body, just not internally. And so I think probably the jury already knew he was there, and there had to be some reason that this was present in these places.
Right. And I think you're correct. There was physical evidence as far as yes, there was semen found on her body, not internally, which I don't think there was an argument that he wasn't there. The issue is more so that having him take the stand and admit to that sexual arousal of such a repugnant crime, right?
Okay.
Sure.
Wouldn't the ejaculation be some evidence, though, that he was aroused? I mean, he wanted, this was consistent with his defense. His defense was, hey, I did not rape her, and here's why. I mean, it seems like it's consistent with his defense.
Yes, it's consistent with his defense. I think the problem is the context of having Mr. Ojeda take a stand where the jury can see him right in person and hear from his own words what he was thinking, how he was feeling at that time is a lot different than having a scientist say, we didn't find DNA. There's something a little more clinical about that, that a jury could listen to a scientist say there was no DNA evidence in these particular places and say, well, why wasn't there? Right now, I've got a question. Shouldn't there be? Should there be? Should there not be? Maybe I've got a doubt. Versus having somebody say to them, "I was there, and even though I didn't do it, I wanted to." Right? That there's more of maybe an emotional response. Maybe they go and they look at what initially was a question for them. I had a doubt because there was no DNA evidence, but this person is standing on the is on the stand telling.
Sort of sour grapes, though. I mean, when we're in trial, we make these choices, right? They're strategic. We have reasons for them. The reasons make sense. And then the trial doesn't work out the way we want. And so now we're second guessing those very strategic choices of his counsel.
Right. In this situation, I think we do have from the record some indication, though, that Mr. Smith was aware that this was a very risky and possibly a bad strategy. He stated specifically that he wanted to limit whatever conversation was being had on the stand because he knew that the more Mr. Ojeda talked, the worse things were going to look for him. He knew that there
Well, not just that, but that it could go to the other charges. I mean, he was trying to really just limit the testimony to the completed rape charges, such that the other charges weren't impacted by the testimony.
Right. He said, my understanding from his testimony or from his testimony at the evidentiary hearing was that he was trying to limit for multiple.
Okay.
Right. That he was trying to limit from the fourth and fifth counts, which involved a different victim, a whole different scenario. He was also trying to limit, again, that exposure for Mr. Ojeda and the ultimate negative that could come from him taking the stand. Obviously, when people are being asked questions on the stand, things come out, and that is how we ended up with some of the more damaging statements from Mr. Ojeda. I think another issue that gets raised with the testimony here and goes back to the strategy that Mr. Smith had is that we don't actually have, I think, specific information from Mr. Smith regarding this case. When I'm sorry, I don't have the transcript in front of me, but when he was asked in the evidentiary hearing regarding his conversations with Mr. Ojeda,
Right.
which was years after this whole the trial went down and everything was finished, he said that he had not reviewed that specific case, that he was speaking in generalities about what he usually does. I usually tell a client this, I usually tell a client that. So we don't actually know for sure if he said those things to Mr. Ojeda. He thinks he does. His memory could be filling in blanks because he hasn't reviewed. He could.
Well, the district court made that credibility determination, though. And are you asking us to sort of reweigh that? Because the district court was clear that they didn't particularly believe Mr. Ojeda's testimony, and that Mr. Smith's testimony about how he typically, and which makes sense. This is a standard spiel, I'm sure, that he gives for his clients, that was given weight by the district court.
I'm not sure if credibility is the right word, but I think there's additional context that maybe wasn't considered.
Okay.
So we have to imagine, right, an attorney and his client sitting in a room having this conversation. They're the only two there. So again, we're getting a he said in this particular situation. We're not getting context. So we can read the transcript, question and then answer, and there's not a lot else that we see. We don't see the mental state of Mr. Ojeda at the time. We don't see the mental state of Mr. Smith. For an attorney to be preparing for trial, that's a stressful situation, regardless of how, how sure you are of walking into it, because you have lots of unknowns, lots hanging on your shoulders as far as making sure you're representing your client in all of their best interests, and you're weighing juries and the prosecutor and the court and what everybody expects of you. There's a lot going through your brain. It could be easy to miss things, including how is your client taking the conversation you're having. So Mr. Ojeda said that he was told he had to testify in order to prove his innocence. And I think, as we discussed a little bit previously, this was the only direct evidence we had besides assumptions we can make from the expert. So this was going to be it. If Mr. Smith says, truthfully, I told him he had a choice. I often tell my clients that they ultimately have to decide, but I can give them an idea. If Mr. Smith testified at the evidentiary hearing completely truthfully, I told him he had a choice. This was his direct evidence, the only direct evidence he was going to be able to provide. Or, he should testify because this is the only direct evidence he could provide. He could be telling us the truth and not necessarily telling us that Mr. Ojeda was in a very panicked state because he's facing 330 months in prison, that, he's not the attorney, not the expert, doesn't know what he's doing. He's relying on the person who represents him to help him. And when he hears, you should do this to provide direct evidence, he says, okay, this is what I have to do. And in fact, in his testimony at the evidentiary hearing, he said, I know the difference between I can or can't, and I should or have to. And ultimately, he felt in that conversation that he had to. So we're missing that context. And it's incredibly important to be able to understand Mr. Ojeda's mindset. Was he aware of what was being said to him? Did he understand what was going on? And I would argue that it's deficient for an attorney to not necessarily pick up on those things, right? To not be able to step back and say, let's go through this, with a lot more detail, right? Here's your risks, here's your exposure. Is this what you want to do? That we didn't get from the record. We don't know, because he didn't examine his notes, if he made any notes on that. I think that would be not unreasonable to expect someone to make notes about, here are the questions my client had, here's what we discussed. We don't know if any of that happened. So we're missing a lot of context. Mr. Smith could have been completely honest and truthful. And unfortunately, we're still missing part of the story. And that ultimately goes into Mr. Ojeda making decisions where he felt like he had to do something that was then detrimental to him, because he appears in front of a jury of 12 people and says, right, I wanted to commit this crime and I was so excited about doing it. This is how ultimately everything happened. So I think for a jury, if we step back to the standard, let me step back to the standard. But first of all, the performance was deficient. The performance was deficient in how he advised his client, what he advised his client to do, and then how that ultimately played out at the trial. And then it was detrimental to Mr. Ojeda that there's a good chance that he was then convicted of those crimes, because the reasonable doubt that might have been formed by that state expert was undone with his admissions on the stand.
I think you're about out of time, and we've asked a lot of questions. Do you have any more questions? I'll give you another minute if you want to hit on this severing the crimes, and then you can address that in rebuttal. I'll give you rebuttal then very quickly.
Thank you, Judge. So briefly on the severing of the crimes, what I first wanted to note was that the statute, KSA 223202, is a permissive statute. It says may join, not must. There isn't a requirement that those all be joined together. There is some case law on that. The state had referenced Hurd and Bunyard in particular. In those particular cases, some of the justifications that were there for, say, joining the cases, like in Bunyard, joining the charges, we don't have here because we have some muddling of facts. And again, if we need to stop, I can certainly stop. But to kind of point out a few things really quickly, we had a situation in this case where the judge had stated that he did rely on the charges 1 through 3 to ultimately determine the intent for binding over in this case. There was a conversation that happened early on about the kind of muddling of those facts. The intent for 4 and 5 was completely dependent on 1 through 3 as far as the charges go. That he had made that comment, the judge was aware of that Mr. Smith was aware of that and even commented on severing and then never actually pursued that. Then we had at trial, the jury instructions were, I think, very important, because the jury instructions come back and say, can we consider April 7th, which was the first incident, charges 1 through 3, when we're trying to consider the intent of 4 and 5. What I believe what Mr. Smith ultimately requested was a response from the judge of, we've given you your instructions, you can consider what's in front of you. And instead, the answer was, yes, you can consider those for intent and then look at the rest of your instructions. I think the state had argued in their brief that, if I'm remembering the language correctly, they had argued in their brief that these were separate and distinct cases, and that was what the jury was advised. However, that jury instruction then saying, yes, you can, ends up muddling those facts so that we no longer have clean cuts 1, 2, 3, 4, 5. We now have 4 and 5 mixed in with the intent of 1 through 3, muddling those facts and therefore creating a problem where we don't have separate and distinct cases or separate and distinct charges. The possibility then that Mr. Ojeda had raised was that if these had been severed and we did not have those counts 1 through 3 or counts 4 and 5, we wouldn't have had that intent. The state would not have had sufficient evidence to convict him of those charges.
Thank you. You'll get your 3 minutes in rebuttal. Mr. Obermeyer?
May it please the court. This case today, it presents a very clear-cut choice I submit to this court as to whether or not the court accepts the factual findings by the district court finding Mr. Smith's testimony at the 1507 hearing credible, or whether it should reweigh that evidence and find Mr. Ojeda's testimony credible. As the court, I'll address the issues as they're presented in the brief. The first being the decision not to file a motion to sever in this case. There was testimony about that from Mr. Smith at the 1507 hearing. He said that he did consider that. The district court, this was back in the trial, noted that there had been a motion to dismiss count 5, which was the attempted rape on the later occasion, the April 15th date, and that had been denied. Mr. Smith felt that one, that would not be a successful motion to sever, and he was obviously referring to the statutes for joining cases there. Clearly, these cases are very similar in character and conduct, and in the alternative, they could be part of a series of transactions. They're located, they took place in the same location roughly, this isolated trail. The targets are the same, young women roughly the same age, and the defendant, of course, is attempting to assault women on this trail. That would be the state's theory. And he did not feel that that would be a successful motion to sever. He also noted that if that was successfully severed, if we have counts 1, 2, and 3 in trial 1, and then counts 4 and 5 in trial 2, the state probably could pursue a 64 or a 6455D motion.
Propensity.
That prior sexual assault in the latter trial. And if successful, that would expose the defendant to a significantly longer criminal sentence. If he's convicted as charged at the first trial, that would mean he's a criminal history A, and then he's facing 2 level 3s of criminal history A, which would significantly lengthen his exposure. Touching on the prejudice part of that, because the defendant was convicted of all 5 counts in one trial, he was maxed out at 330 months in KWC. So even if we have some form of error on that case, it's not in failing to sever them. There's really no prejudice which the defendant can establish, and even today we don't really have any argument of prejudice. And I don't.
So are you arguing that even though in the trial that took place, the jury questioned, can we consider 1, 2, I may be getting the numbers wrong, 1, 2, and 3 when we're considering 4 and 5, that would have been allowed probably anyway if the cases had been severed?
Yes, and there were comments, and I believe Mr. Smith noted that in his testimony as well. And that was, and I cite the statute as well in the brief. It seems like that would be textbook 64.
And this had gone up on a direct appeal, right? So that the whole jury question response, that was affirmed on appeal, right? That there was no error there.
That is correct. Another panel of this court considered whether the district court abused its discretion in responding to the jury's question and found it did not.
Okay.
It accurately answered the question. So long story short, the jury could consider the events on April 7th for what happened on April 15th. Turning to the decision to testify again, this is a question of reassessing the evidence. Mr. Smith did testify in generalities, but he did specifically testify, and I believe you can find that beginning on page 36 and then going on from there of volume 2. His discussion specifically about this case, he did recall that they discussed whether or not the defendant should testify. He said that they did so at length, and he testified that he never tells his clients to testify. He only can make recommendations. He did say that he makes strong recommendations, and I believe the testimony was that he strongly recommended that the defendant testify in this case. Under the totality of the circumstances, that's not an unreasonable thing for an attorney to say. While it is true that the state's expert couldn't testify that any semen or ejaculate was found inside of
Victim.
the first victim, and that all of the semen was found on her clothes, that still doesn't address what the state argued in closing, whether or not there was actual penetration.
Well, I think the testimony was there was no DNA, and theoretically there would be DNA from not just ejaculate if there was. I mean, that I think is what they're arguing, right? That if there was penetration, there would be DNA from just rubbing.
On the in the interior,
Yeah.
that would, yes, that was the argument. That's the argument that's being made today, that there would be DNA on the inside of HT.
Well, and Mr. Smith argued that, I think, in closing argument,
He
didn't he?
did,
Yeah.
and he said that there was not one cell found inside
Right.
of her, which goes to show that Mr. Ojeda is telling the truth when he's saying that when he tells the jury that he did not penetrate, that he was
Mhm.
too excited. He did not actually complete the act of
Right.
rape, which, as this court knows, if the jury believes him, would result in a not guilty verdict for
Mhm.
those counts.
Didn't Mr. Smith testify at the evidentiary hearing that he did remember at least some things about this case? It was 5 years before. He didn't remember specifics, but he remembered his strategy was to try to prove that this was just attempted crimes and not completed crimes.
That is correct. That was Mr. Smith's testimony, that he discussed that with Mr. Ojeda, and he also testified that he knew that's what Mr. Ojeda would testify to. That was consistent with his prior conversations. So he wasn't surprised. I believe floored is the way it was put, and he wasn't floored at all. This was Mr. Ojeda's testimony. It's what he expected. It's what he discussed with Mr. Ojeda, and ultimately it's the decision that Mr. Ojeda made. So under these circumstances, we have neither deficient performance, because this was a reasonable thing for an attorney to do under the totality of circumstances, nor do we have prejudice because essentially the same evidence had already been presented. It was very damning evidence. Obviously, in this case, under these circumstances, and any defense attorney, this was a textbook, admit the act, but deny guilt. Based on that, I would ask this court to affirm the findings of the district court, finding that Mr. Smith rendered not just reasonable, but more than reasonable representation in this matter, and to affirm the denial of the defendant's 1507.
Thank you. Ms. Legeman, let me ask you about this severance issue again. What is your response to Mr. Smith's argument that even if the cases had been severed, evidence of the first case would have certainly come in the second case anyway, so that perhaps you don't gain anything by severing them, and by severing them, you increase his jail time exposure considerably because they'll use the criminal history from the first case against him when it comes time to sentence in the second case.
Judge, I think that's I think that's a concern that should have been considered by Mr. Smith. Obviously, he did consider those things.
Mhm.
There is not a guarantee that that is how things would have happened. For example, when the state argues that if we had tried the first victim in the first case first, then we could have used that information as 60 or 55 to bring that evidence in. Had the second case, for example, been tried first, then we may be in a different situation as far as how the information gets presented to the jury and what can be presented. So I think there's an assumption here, maybe by Mr. Smith, that he would have been unsuccessful with the severance, and that even if he was successful, he'd be unsuccessful with the 64-55 motion as far as the state trying to bring that evidence in. But I think an assumption that you lose isn't a guarantee that you lose, and it isn't a reason to avoid doing something that could potentially help your client. So
It isn't the whole point of a strategic decision by counsel to weigh the risks and benefits, and the decision to sever would be a strategic decision, correct? Made by counsel that we'd have to view as a strategic decision. Go ahead.
I do believe that that would be a strategic decision.
Mhm.
The standard for deciding these cases, right, is this a strategic decision? Is it a reasonable decision to make?
Mhm.
We would
Or do you think no reasonable attorney would have made that decision? Maybe looking at it that way, is there no reasonable attorney out there that would have made the decision Mr. Smith made in this case?
that's a hard, right? That's
Right.
a hard general question to answer, right? Because I don't know what every attorney would do. I think that ultimately, in looking at the facts of this case, we know how damaging counts 1 through 3 were
Right.
in the context of counts 4 and 5. That doing everything in your power, even if you lose, to try to prevent that damage to your client is necessary. So I do think that even if a client or even if an attorney thinks they're going to lose at something, it's not a guarantee that they will lose, and it doesn't mean that they don't try to do it.
But then he has to weigh the risk of his client's increased sentence if those are severed. He has to weigh those two things,
He does have to weigh those two things.
knowing that assuming that the cases go in chronological order, and you've got to assume the prosecutor is going to do everything they can to make sure they go in chronological order. It doesn't seem at all unreasonable to believe that if they go in chronological order, they're going to get in evidence of the first crime, and then he's faced with a much bigger sentence.
That is a possibility. Yes.
yeah.
I said again, unfortunately, since these are hypothetical situations, because we
Right.
know what we have.
But isn't that what strategy is making a risk assessment based on what we think might happen?
It is. And I think that's why even if, we're not conceding any argument
Right.
regarding that point, that even if that is not, the court does not agree with us on our stance, when we get to the testimony and how the trial actually did take place,
Right.
we still have prejudice based on Mr. Smith's ineffective assistance to his attorney or to his client at that time.
Okay.
I had noted based on the state's testimony today, he made reference to whether or not the jury would believe Mr. Ojeda, and even if they did believe him, he's admitting to being there. And I wanted to point out that the burden of proof for the state at a trial level is beyond a reasonable doubt. And so there are cases that people are found not guilty, or the jury even hangs on a situation where there is a reasonable doubt there. So Mr. Ojeda doesn't have to prove, yes, I am correct. He has to provide that doubt. Ultimately here, I think, would a reasonable attorney prevent his client from getting on the stand and admitting to things like, I intended to rape this person and I was this excited about it? Yes, I think they would try to prevent that. I think Mr. Smith knew he needed to prevent that and did not do it effectively. I think ultimately then the prejudice that came in was that any reasonable doubt that existed from the DNA evidence was then wiped clean essentially by the negative impact of Mr. Ojeda's comments on the stand.
Thank you. I think that's your 3 minutes. Any questions? Yeah. Thank you very much. Excellent briefs on both sides. Very, very well argued. This is going to be a difficult case. Thank you both, and we will get a decision out as quickly as possible. Next, I call case number 124605, NVLCC LLC versus NV Lenexa Land Holdings LLC versus Steve Sobek et al. The parties would step forward and state their appearances, please. Come on up, come on up.
Plaintiff NVLCC appears by its attorney, Justin Valbiers.
I'm sorry, what's the name?
Justin Valbiers.
There, Valbiers, okay. Just couldn't hear you exactly.
Please the court, Robert Caldwell on behalf of the defendant.
Mr. Caldwell. Okay, Mr. Valbiers, do you wish to reserve any time for rebuttal?
Yes, Your Honor. The balance of the time that I don't use, I would like to reserve for rebuttal.
What if you don't have any left?
In the event that I don't have any left due to questions, then I would request to reserve 3 minutes.
Okay, all right. I'll try to figure that out. Okay, thank you. All right, you may begin.
May it please the court. Plaintiff appears by Justin Valbiers, its attorney, and wishes to reserve, as previously stated, any time not used for rebuttal.
Yeah.
The facts of this case are lengthy, and so the plaintiff is going to whittle that down into what it believes is necessary to satisfy the essential elements of its civil conspiracy claim. I will begin by stating that this case was preceded by entry of an award in arbitration, finding that an individual named Zach Henderson breached his fiduciary duty to the plaintiff, and that plaintiff suffered damages of $283,000 approximately as a result of that fiduciary breach. At trial, the parties stipulated that the facts determined by the arbitrator, all the findings of the arbitrator, would be accepted as stipulated facts at trial. Those stipulated facts, as relevant to the issues on appeal, are as follows. In October of 2016, Zach Henderson created an entity named Elux Homes LLC and appointed his wife, Jessica Spalding, as its 100% owner and manager. In March of 2017, Zach Henderson created another entity, the defendant in this case, and installed his wife's company, Elux, as its 100% owner and manager. Shortly thereafter, in March of 2017, Henderson, while acting as manager of the defendant and as manager of an entity named North Village Fund, caused North Village Fund to transfer to the defendant its sole asset, real estate located in Lenexa City Center, in exchange for a promissory note that was deemed to be egregiously one-sided and unsecured, and to have caused damage to the plaintiff, basically. So as a result of that, plaintiff found out about the transfer to the company owned by Henderson's wife and filed an arbitration action. And it was stipulated at trial that the arbitrator determined that Henderson, on behalf of both entities, the NV Lenexa and the defendant, or North Village Fund, sorry, and the defendant, he was responsible for all acts relating to the transfer of the properties and the sale transaction. Now, there's been back and forth between whether it was framed as a transfer or as a fiduciary breach. I want to make clear that it has always been, as established in our reply, the principal argument of the plaintiff that the fiduciary breach would automatically establish the unlawful overt act of the civil conspiracy claim. That's why we abandoned all of the claims that were in the case. It initially started out as a fraudulent transaction claim, which was before the arbitration award was entered. And then once the arbitration award was entered, the facts were so perfectly fitting into the elements that we got rid of every other claim because it was such a simple case, and then lastly, I just want to continue with the stipulated facts at trial. It was stipulated that Henderson's actions relating to the transfer, which were committed on behalf of both entities, breached his fiduciary duty to the plaintiff and caused damage to the plaintiff in the amount of $283,333 plus interest. So,
Before we go on from that, I want to.
yes,
So was it stipulated at the district court level what the alleged overt act was? Because in the briefing, it seemed in your reply brief, I think you clarified it, but what was stipulated in front of the district court regarding the overt act?
So the overt act was not stipulated. It was a stipulation in the pretrial order that provided that the findings of the arbitrator were going to be stipulated findings in this case. The reason why I said it was stipulated is because it was stipulated by consequence of being included in the arbitrator's findings that Henderson's acts breached his fiduciary duty to the plaintiff. So there's a distinction there, but no, the defendant didn't stipulate the overt act was satisfied by that. But it was established that the breach of fiduciary duty occurred, and it was our argument that, and I think it's a very good argument, that the unlawful overt act was satisfied by consequence of that fiduciary breach. So moving on to the issues before the Court of Appeals, the first issue on appeal is whether the district court committed legal error when it found that plaintiff failed to establish the unlawful overt act, strike that, failed to establish the first element of two or more persons because defendant and North Village Fund were both managed by Henderson. I think the law in Kansas is clear. The law in Kansas provides that entities share their own separate legal status. It was stipulated at trial that Henderson committed all acts relating to the sale transaction on behalf of both entities. It was stipulated that NVF agreed to the terms of the egregious one-sided terms through Henderson. It executed the documents related to the sale transaction on behalf of Henderson, and it granted the defendant multiple one-year extensions of the promissory note without consideration through Henderson. So
Is there any evidence that Henderson was acting independently from NV Lenexa Land?
Henderson was the sole person authorized to act on behalf of.
Right, is
the
there
NV
any allegation that he was doing anything inconsistent with what NV Lenexa Land?
Absolutely not. The only evidence presented at trial was that Henderson was replaced by a manager named Andrew Talbert 3 months after the acts constituting his breach of fiduciary duty. No other evidence was presented that he was not acting or authorized to act on behalf of the defendant.
So, okay, so we're looking for two or more persons, NV Lenexa Lands. Sorry, we've got a lot of
We've got a lot of initials.
initials here. So, you're arguing that he was acting on behalf of NV Lenexa Land
Holdings, yes.
and
North Village Fund LLC, which was a wholly owned subsidiary of Parthenon Investing, which is the relevance of Parthenon. Parthenon wholly owned and managed North Village Fund, and that is who owned the property that was transferred from NVF to NV Lenexa by Henderson.
But Parthenon isn't in this conspiracy.
No, it's just by consequence of its ownership in the operating agreement in the arbitration, which may be confusing.
Confusing is an understatement.
okay, and so when Henderson is acting for North Village and NV Lenexa Land, are both entities receiving the same benefit, or are there different benefits?
I don't understand the question necessarily because he can't act simultaneously on behalf of both entities. He acts for both entities while performing separate acts. So if he signs an agreement, so like if there's an agreement between North Village Fund and defendant NV Lenexa, he can only agree to the terms on behalf of NVF while he's acting for NVF. So it has to be separate.
Okay.
It can't be concurrent or contemporaneous. But so he set and agreed to the terms of the NVF note, but he agreed to the terms on behalf of both entities separately.
The only actor we have here is Henderson.
That's what makes
So
it so
what's your what's your best argument that Judge Gurney was wrong to say you can't conspire with yourself? If he was never acting independently, and he was acting in his capacity as manager of these groups, who was he conspiring with?
I will say, so the intercorporate conspiracy doctrine, which you're referring to, which was not referenced by Judge Gurney, but after looking at the cases, that's what I determined he was using. That's used to prevent individuals generally, and I mean, it's just kind of off topic, but it's used to prevent individuals from being, or actions against individual from being concurrently held against the entities. But when multiple entities in that Intrust Bank case that I referenced, which is the only reference I could find in Kansas to alluding to the intracorporate conspiracy doctrine, provides that when he's acting for NVF and when he's acting for NV Lenexa, these are separate entities with separate interests, and they are not, basically, there has to be multiple entities. If there's two sides to a transaction, there has to be multiple parties involved because they each have their own separate interest. Yes, technically Henderson had his own interests involved and was controlling both entities, but for purposes of the legal analysis, there are multiple entities. And I will say that if there was only one person here and not two or more persons, then the claim against Henderson would automatically translate to judgment against, it would be judgment against the defendant already if he was just one person. If you were to find that Henderson and the defendant were one person, then there would automatically be judgment, but that's not the case. We have to pursue joint and several liability under this theory. So
What did the arbitrator, I mean, what was the basis for the arbitrator's finding?
the basis for the arbitrator's finding with regard to,
To the liability on the fiduciary, breach of
it
fiduciary
was
duty.
against Mr. Henderson personally only. Henderson was a necessary part of the arbitration because he was a party to, but NV Lenexa couldn't have been included in that proceeding.
Right, so Mr. Henderson is already then paid whatever his obligation was for breach of fiduciary duty.
Oh, no, there's a single, it would be joint and several liability. He wouldn't be paying separately. It would be, there's one liability. Does that?
Well, that's what I'm trying to figure out here. The arbitrator was only against Henderson. The arbitration's award was only against Henderson
Correct.
personally. So you're not saying in this case that the two entities conspired. You're saying that Henderson, who's conspired with one entity or both entities?
With the defendant only. Because, I mean, for purposes of our civil conspiracy claim, Henderson, as manager of NBF and technically personally, due to his personal liability, conspired with the defendant that he created to carry out this very purpose, which was the transfer of the land, which breached his fiduciary duty to plaintiff. So I don't know if that answered your question.
We'll go.
The arbitrator did not address the liability of NV Lenexa in any way, which required this lawsuit.
So Henderson's out of play as far as this lawsuit, other than he's a representative for the LLC.
Yes, yes, Henderson's out of play in this lawsuit now. We already have judgment against him. We weren't seeking anything from Mr.
And that was confirmed by, or the arbitrator's award was confirmed by the district court.
It was not appealed and it was a final order.
And this may or may not have anything to do with this, but your client, the plaintiff in this case, what have they been out financially?
That was an argument referenced by the defendants. In addition to legal fees and the fact that they were not able to share in the potential profits from the development because they were basically,
Put out?
yeah. But I don't know the exact amount. I want to say it was just in the single thousands, but I mean, I don't really understand the relevance to the,
Okay.
I mean,
I was curious when Henderson was assessed 280,000 and there was something in there about receiving 23,000 on a $3,000 investment or something. My question is just what kind of money are we talking about being involved here?
the $283,000 was the arbitrator's determination of the 1/3 value of the equity in the land that was lost by kicking him out. Yes, Henderson, after the fact, just sent a check to Sobek, but It was related, I mean, it wasn't related to the original determination by the
Right,
arbitrator.
right. Got
And
it.
you're not seeking those same damages in this lawsuit.
No, no. This is just joint and several liability for the judgment entered against Henderson. I think I'm using more time than I was expecting. How much time do I have left?
Um,
I'm sorry.
you are about 2 minutes over. If you want to stop now and have some rebuttal, or if you want to go on for 3 more minutes and take up all your time, that's fine. Well, that didn't add up, but I'll give you, that didn't add up at all. I'll give you a couple more minutes if you want, or I'll give you a couple minutes in rebuttal, whichever you prefer.
I will reserve time.
Okay. Mr. Caldwell, I did not get A's in math, just so you know.
If it pleases the court, Robert Caldwell, on behalf of the defendant in this action.
Right.
You got interchanged previously during the argument. I'm going to try to clean up some of this, and then you can bombard me
Please.
with questions.
Please do.
Mr. Henderson was one of 3 investors in Parthenon.
The first.
Yes.
Parthenon was the original.
And one of the investors would be Mr. Sobek. So they had this LLC. They created another entity to hold property, which was the development, basically vacant land to be developed into condos over at City Center Square.
And what's the benefit to such a setup? Is that common in business property practice to
It is
have
in
a
business-
separate entity hold the land?
It is very common in business
In-
dealing with properties so
Property
that your
first.
liability is focused on that one entity if you're holding 100 different developments.
Okay,
So you got to kind of think
okay,
big time
Big.
developers,
big.
but it works its way down to everyday folk.
Okay, got it.
Part of this was $850,000 parcel.
Mhm.
The 3 investment groups that created Parthenon totaled $10,000 in investment, about $3,400 per person. That's Mr. Sobek's investment into this deal. They tried to develop it. They couldn't develop it. They couldn't get investors to come in. So they started shopping, so to speak. They had a note on that 850 with what's called sagebrush. They started foreclosure action to get the land back. Now, if you've got starting company with $20,000 for $850,000 property, you're basically going to get wiped out through that foreclosure.
Yeah.
So then they got real looking at property. He had the ability under their operating agreement, he being Mr. Hendricks, to transfer that property as long as 2 of the 3 investors agreed. So he did that. And that's where this NV Lenexa, which would be my client,
Mhm.
comes in, and he did a deal from one property, which he could, to this new company, which would be my company that I'm here for.
Mhm.
Mr. Sobek sued him for breach of fiduciary duty for his duties under Parthenon.
That's not-
That's what went to arbitration.
Mhm.
In that arbitration, Mr. Sobek threw out numbers that he lost X number of dollars because the note that was sent and executed with NV defendant, it was extended without consideration. So he brought that into this claim as a breach of fiduciary duty within Parthenon.
Mhm.
And that's the arbitration.
Mhm.
The arbitrator found that there was no unlawful, the transaction itself was not improper or unlawful, but that Mr. Henderson had breached his fiduciary duty in that he didn't get monies for the extension. And it was a note that wouldn't have a monthly payment, just an interest rate.
Mhm.
And so he said, we should have this kind of money. That's where the number comes up. The arbitrator said $283,000 for the breach of fiduciary duty. The other claims, basically that Mr. Henderson did with NV Lenexa were asserted against Mr. Henderson there. Now they're trying to collect from NV. Now, when we get to two entities and we talk about conspiracy, it does not say two corporations. It says two persons. So that's persons. Entities are just that, they're entities. And if you go through the case law that I've cited, an entity is not a person. So that's why Judge Gurney says there's only a party of one here at the table. And that party of one is Mr. Henderson. And all you're trying to do is, because the arbitrator gave you X, now you want us to pay it. You want my guy to pay it because Mr. Henderson has not paid it. And so what we did, because NV now couldn't move the property because you have this lien against it, Liz Pendants, they had to sell the property. And in order to get clean title so they could get an investor to buy it, they put aside, we agreed with Mr. Sobek to put $350,000 from the sale basically in an escrow account, which is the attorney for plaintiffs, he put in his trust account. And so it's sitting there. And what the court said in its opinion was that this is just an act of one, so it's not a conspiracy. And there's no unlawful act because it's not unlawful for NV to enter into a real estate contract with the other entity. There's nothing unlawful about that. And so those are you don't have element 1 or element 4 in a conspiracy.
In order to transfer, there needed to be two Parthenon.
Correct.
Henderson's one.
Mhm.
Who was the second one?
The third one is Mr. Robinson.
Robinson.
And that's all set out in the courts, how he establishes the entities.
And it basically said Robinson is really kind of got nothing to do with all this. He was kind of a silent, do what
Correct.
you want kind of guy. Okay.
He agreed when they basically removed Mr. Sobek as the manager. You need 2 out of 3.
Right,
So Robinson and Henderson removed him.
right. Mhm. The world of property law.
This is the world of property law. But I think if you look at this, the judge is right. What they're trying to do, you had this case over here and an arbitrator gave you X against Mr. Henderson. And in that case, you tried to get everything, including how you think Mr. Henderson over here with NV didn't breach his fiduciary duty with Parthenon. Well, that action's here. It's not, 2 entities are not conspiring. You need 2 persons. You got 1 person. That action goes back to the arbitration. And the arbitrator just ruled it's speculative. This is what he did. And it wasn't the transaction itself. It was the note underlying the transaction. And that's how he came up with the 283. It is very convoluted.
And so are you saying Henderson didn't pay the 283, so the plaintiff is now going against NV to pay that same amount as joint several liability for conspiracy? Yeah,
For a conspiracy of 1
right.
without an unlawful
Got it.
act. And that's why the court ruled why the court did. It takes a while to dissect these facts. But you had a very learned judge. He had the witnesses, he had testimony, he had stipulations. And you have to be careful when you read those stipulations because they read them far different than I do, the arbitrator does, and the court does.
Can you explain why it wasn't unlawful though why this wasn't a breach of fiduciary duty to transfer this note with no consideration?
I can probably tell you my response. If you think about it,
Okay.
NV Lenexa,
He couldn't make this argument without his
Without your
hand.
hand.
good, and I apologize.
No, we
Did
need
you-
another,
Yeah.
we need another hand.
If you think about
Uh-huh.
NV Lenexa doesn't owe a duty to Parthenon. There's no duty owed there. It only comes from Henderson. And that's why you had the case there. NV Lenexa owes no duty to Mr. Sobek or Parthenon. There's not a fiduciary duty. And one of the factual things that you might find more fascinating, Mr. Henderson was never an owner of NV Lenexa. He never got a nickel from NV Lenexa. NV Lenexa is a bunch of investors, shareholders, members.
And you're saying Henderson's not a member of NV Lenexa?
No, he just formed it.
And manage, he's the manager.
He was temporarily the manager until they brought in Mr. Talbot, who had the investors that could make this continue to work for a while. And so there's no duty on behalf of NV Lenexa back to Parthenon. They're in negotiations of a contract on behalf of their shareholders. If there was a breach, it is Mr. Henderson, and that is a breach to Sobek in Parthenon. I hope to try to clear up some of this.
Helps, and I'm sure your co-counsel will try to correct anything he disagrees with. Any other questions?
I don't think so.
No,
in
take it-
fairness to us, he tripped over the names also.
Right, I know.
And he's been doing this long.
Okay,
He-
Okay, thank you, Mr. Caldwell.
During the trial, we decided we're just going to be plaintiff and defendant because you have so many NV this,
Right.
NV that.
Right.
Okay, thank you, Mr.
Thank you.
Caldwell. Okay, Mr. Balbiers, if you'd like to take 3 minutes to tell us why he's full of it.
Your Honor. So I will start by saying that in response to his contention that entities can't be persons for purposes of civil conspiracy, that's false. The cases bear that out. I've never seen that once. He's again referring to the intercorporate conspiracy doctrine, talking about agents conspiring with their principals, the corporate entities. Entities can easily be found as their persons under the law with respect to civil conspiracy and everything else. With respect
What
to
about the unlawful act? You're still saying it was the breach of the fiduciary duty that was the unlawful act.
breach of fiduciary duty committed by Henderson while acting for NVF and NV Lenexa. So
For that, whatever short period of time he was managing NV Lenexa.
he managed them for a little bit, I mean, it was months, but yeah,
Oh, okay.
with respect to this transaction, yes, it was a short period of time. But I will say that it was clearly preceded by his creation of Elux in October of 2016. Then he created NV Lenexa in March 2017 and appointed his wife's company as its sole owner. The investors came in long after they had acquired the property for the egregiously one-sided note. With respect to his discussion about the findings of the arbitrator, there were multiple claims. Parthenon was sued. The managers were sued. The transaction was found by the arbitrator to be unlawful. He determined that it was unfair, that the terms were unfair. It resulted in a judgment of $283,000. He didn't feel that Parthenon had violated its operating agreement, and the arbitrator didn't find that Mr. Robinson did anything wrong, and that it was all orchestrated by Mr. Henderson. But he definitely found there was something unlawful, that the transfer was unlawful. So this notion that the transfer was lawful is ridiculous. The arbitrator could have been maybe more succinct in his points, but I think if it's looked at under that lens, you can see that it was not a fair transaction. And he expressly states it was an unfair, or he says the unfairness of the transactions demonstrated by the terms and subsequent handling of the note. Express. So
Is an unfair transaction an illegal transaction?
I would argue that they're synonymous.
Okay.
Unless you're talking about illegal being criminal,
the
then I would say
fiduciary
they're not the same.
Because of the fiduciary duty,
Uh,
the connector?
Correct. I don't think it's illegal, like as a criminal act, but which is somehow how I think of illegal sometimes. But so just in brief, to summarize, The elements of civil conspiracy are two or more persons, an object to be accomplished, a meeting of the minds and the object to be accomplished, an unlawful act, and damages. Two or more persons, Henderson and defendant. Object to be accomplished was breaching his fiduciary duty to Sobek. A meeting of the minds, that element's established by the fact that at all times relevant, Henderson shared the state of mind of the defendant and Henderson shared Henderson's state of mind. It's perfectly met, as are the damages, or as was the unlawful act as stipulated to, that Henderson breaches fiduciary duty per the arbitrator. And then the damages are the stipulated damages that the arbitrator found plaintiff suffered as a result of Henderson's breach of fiduciary duty. So the pieces fit perfectly. I understand that the number of entities, clearly we didn't do a good enough job of describing the entities and all the moving parts. But when you boil it down to the facts I discussed earlier, it is clear as day. And I just hope that you'll give it the attention that it deserves.
What is what is the remedy? Did the district judge, I know he ruled against your client on 2 of the 5 factors. Did he find in favor of your client on the other 3 factors, or did he just not get to them because he had? So what would be the remedy if we accept your argument?
We asked the district court to rule on the remaining elements. He withheld ruling, so he didn't rule in our favor or against us.
So we would have to remand if we.
Initially, it was our intention to request remand, but upon further examination, I think that the stipulations, as previously discussed, establish each of the 5 elements. Now, I don't know if that's protocol. If it hasn't been ruled on, then whether you have standing to address those separate elements. But
I don't know if we have to have standing, but it is unusual for us to be the first finder of fact.
So yes, the stipulations that I've discussed, I think clearly perfectly satisfy each of the elements. But the district court did not rule on them. And so if remand, if you disagree with its rulings on the first 2, then yes, I think.
And then just another housekeeping thing. On our docket, it's listed as having also Steve Sobek et al. As defendants. Are we really just to focus on NVLCC LLC and NV Lenexa Land Holdings LLC and not focus on these other people that may have been named and aren't with us here today?
That's correct, Your Honor. The counterclaim, there was a counterclaim that was denied against Sobek, and I mean, that counterclaim was dismissed and not appealed. So
just want to make sure they're not a party to this appeal.
that made it on there. Sorry.
Because it was in the caption at some point.
Yeah.
They just carried a
Yeah,
caption.
thank you.
Thank you very much. This is a very complicated case. It's made me decide I'm going back and drawing a chart. Do you have, well, you should have included it in your brief.
My boss told me not to.
Oh, well, your boss was wrong.
That's
Tell
right.
him we like demonstrative information. For visual learners like me, that would have helped, but we'll get a chart drawn. So thank you very much. But very well briefed, very well argued. We will get to this as quickly as possible. May not be as quickly as some, but it will get out. Okay. Thank you very much to both of you. We will stand